the time, but I've got evidence now. Then he's taken her to the police station, making further complaints, and even the police have said there's nothing happened. It's actually in their own paperwork that they've had to tell him to go away. And then the police said to him and her to get an injunction on me. Well, how can you get an injunction on a mother that hasn't seen you? The police have threatened me away from her, so I can't contact her. Yeah. So, you know, how can you get an injunction on someone who hasn't seen you to keep you away?
Mm-hmm.
So, come February last year, 2010, a man comes to my house, serves me with an ex-party non-molestation order. And I think, what? Non-molestation order for me to stay away from my daughter when I've seen her? Yeah. And there was another member of the public's name on it. There was another one. Well, living at the house on my own, the person who they were referring to hadn't seen my daughter for 5 years anyway. Has to be within a 3-year limit.
Mm-hmm.
Yeah. So, anyway, I told him about it because he's a vulnerable person. He's legally classed as a vulnerable person. So he got upset and thinking, well, when have I seen your daughter? I haven't seen her for 5 years, and I can prove it. Yeah. Anyway, so I represented myself and him at the first hearing.
Mm-hmm. So you fought the order?
Of course.
Right.
So I turned up, and Judge Cleary, because she was represented by Blakemore solicitors, who were out-of-town solicitors. And the fact that she's been under cams and she's legally classed as a vulnerable person, she's supposed to have someone with her, not be with the solicitor on her own, because he's getting paid anyway.
Yeah.
It's a conflict of interest.
Yes.
Yeah? And he didn't do that. So the non-molestation, it was done ex parte, so I turned up at the court and I explained to Judge Cleary that this man who's with me is not family. Yeah, he's not legally allowed to be in any family hearings. Yeah, he's a member of the public. So Judge Cleary had a go at Blakemore solicitors and told him what section if he wanted to do him under, but certainly not in the family courts. Next hearing, he was pursued into all of the 6 months of hearings. A member of the public. Yeah, I had to do like all his writing up because he's a vulnerable person. When I read her affidavit, it was heartbreaking because whether they've done NLP or brainwashing or whether she's been threatened what to say, what's in her affidavit can be proven unequivocally to be untrue.
Right.
For example, she said I took her out of school.
Right, which wasn't true.
Well, it's proven not to be true.
Absolutely.
Yeah. There was things there, and when the judge would have looked at that ex parte affidavit, he could never do an order on it because I hadn't seen her for nearly 2 years at that stage. Yeah. When we lived together, there was no police at our house. There was no problems between us, so there was never any complaints. If you read it, anyone reading it, even the solicitor who typed it up, wouldn't he say to her, well, how come you was off school for 2.25 years? When did it ever go to court? The whole thing, if you read it, it's crazy. And it proves itself to be false. Yeah? So, any normal person reading it, she'd gone to a few other solicitors, they wouldn't do it. they turned it away. It was actually in her affidavit that she'd been to other solicitors that wouldn't deal with it because they knew it's not natural what you're reading. So Blake Moser took it up. There was an ex parte order done behind my back. The first hearing, it was established that the man shouldn't have been there. They continued to pursue him into all 4 hearings. I asked for the education evidence, which was commissioned. I asked for the social services records, which was commissioned, when they only visited twice. I asked for the police evidence to do with their false arrest, which was commissioned. There was a hearing booked for the 26th of May. I had 14 days to write up my defence. They then get 7 days to look at it prior to the hearing. The judge has a checklist that he has to tick and verify. Is all the evidence in? Is photographs in? Is this in? Is that there? So he'd arranged for a full day's hearing. The only evidence that was in its entirety, which I've responded to, was the social services evidence. The police evidence wasn't there. The education evidence wasn't there. But the barrister showed me a sheet of paper, a couple of sheets of paper that had blackouts in it, red X, they call it.
Redacted?
Yeah. And he'd show it me and he said, this is the police evidence. I said, well, where's my copy? I should have had this a few weeks ago. Oh no, we've only... And he wouldn't give me a copy of the stuff that was going to be put before the court where I was refused to defend it. So this was Judge Clary.
Well, that's in breach of legal process.
Yes. Yeah. So Judge Clary...
Certainly in breach of lawful process.
Yeah. And Judge Clary, I had 3 hours of argument with him and refused to go ahead with the case. I said, there's police evidence being used here that I've only had 10 minutes to scan, and it's been kept from me. You won't give me a copy.
Redacted.
I had 14 days, 3 hours. Yeah, there was a barrister fighting me and a judge fighting me. Do you know what the judge said as soon as we went in? He said, I believe the affidavit.
So that's before he's even heard anything from you?
So, yeah, but he's not legally allowed...
No, of course not.
...to decide on
That's
the
what
case.
he's there for. He's there to make a judgment on the evidence.
Judge Cleary, immediately going in, he said, I believe the affidavit, so we may as well hear it. We don't need the evidence. I said, I'm not going to take part in this. And then he asked me to go away for about half an hour and look at this Red X paperwork and then come back and argue the case. I said, no. I said, if I cannot put my defence in writing where I've got a record, because these hearings are corrupt, they're not legal, they're corrupt. I said, you're bringing someone in, a member of the public in, you're harassing him. Yeah, I said he's a vulnerable person. Yeah, my daughter's a vulnerable person. She's not represented. He's not represented. So, in the end, I refused. 3 hours of argument, I still refused. It wouldn't go ahead. So he adjourned it. He finally adjourned it. So immediately I put an FL 403 in on Judge Clary for a stay on proceedings, for breach of the Human Rights Act, the Convention, all sorts of things. And I filled all that out, paid for it to be done, which goes into their accounts, it can't be lost. Then he wrote me a letter saying he's going to hear the next case. The next hearing was a different judge. It was a Judge Orme.
That's not normal at all, is it? That's not normal procedure, because the same judge would normally stay right through the case.
Yeah, but he, because I wanted to get it to the High Court, because the reason why it couldn't, you see, a county court does not have jurisdiction to hear criminal offences. Now, with the education, the affidavit proves it's criminal offences because there was no court action. Yeah. They'd never had the jurisdiction to hear the case anyway, because there was criminal offences committed against my daughter by the school. So it could never be heard there. Which is what I explained to him. I said, there's criminal offences. You don't have the jurisdiction, and you're refusing me my evidence to do with the criminal offences. I said, I'm being accused of taking her out of school. I'm being accused of a criminal offence. I take her out of school. 6 years later, nobody. I haven't been to court. She hasn't been provided with any education. She's been refused access.
Travesty, basically.
Yeah. So then we had a short interim hearing with this judge on. I asked for the police tapes from the arrest, because in my police tapes I said she was a vulnerable person, she'd been under cams, they refused it me in '08, and the police refused to supply it to the court, which was court-commissioned defence evidence. So then they gave my tape, which they refused me, to the court and Blakemore's. So they had access.
But not to you?
Yes, not to me.
How can they possibly justify that?
Well, I've got the
justify,
evidence.
There you go, there's a good word.
Yeah, I've got the evidence. And they asked Blakemore's to transcribe it in-house. They didn't have in-house transcription services, so they sent it off to only 3 of what the police would let them send it to. Yeah? They said they can only send it to one of their 3 people that they will allow them to send it to. So I knew there was something wrong, and when I seen the transcripts of my police interview, they were falsified. And when you read them, you would have to be absolutely as thick as anything. When you read them, you can tell they're falsified. And there's no mention of my daughter being a vulnerable person. There's no mention of her being...
All of which was in the tapes?
Yes. But in her transcripts, that's when I found out that they accused me of pressing charges